All right, moving on to our next presenter, Aaron Johnson. He's going to explain effectively how to use pretrial services, bonds, personal bonds, bond conditions, and risk assessments. Mr. Johnson was appointed the Director of Personal Bond Collections and Magistrate Courts for Galveston County in 2019. Prior to coming to Galveston, he served in multiple roles across the country. He has been very active on pretrial reform and development for the past 13 years. He serves as chair of the Education Committee for the National Association of Pretrial Service Agencies. I am very pleased to welcome Mr. Aaron Johnson. Thank you so much for coming, and we look forward to hearing what you have to share with us.
Thank you very much. Good morning, everyone. I am here. I like the tee up. I appreciate that very much because I am here to remind you, most of the people in this room who are making those decisions about letting people out and on what conditions and how much money and things like that, I'm here to remind you of the reason we're going through and doing all those things to begin with. So, sure. Oh boy, let's see. Okay, got that. Very good, very good. Okay, thank you. So before we even get started, we just had our national conference for the National Association back in in September. And I had a public defender come up to me and say, you know, we can sum up a lot of what occurs during the pretrial process in one statement. He said, we put people in jail for not following laws that they don't like. Okay. Why are judges any different? Not that I'm here to put you in jail. That's not the connotation. But who does hold the people responsible for making those decisions, and whether or not those decisions are based actually on the law or their bias or how they feel at the time? So think about that as we move through this presentation. The reason pretrial is important is because we are arbitrarily holding people, taking their liberties away because why? There are only two justifiable reasons to hold somebody pretrial. These are not convicted individuals. One is we feel that they're a flight risk. And I don't mean they had daycare issues, they had a doctor's appointment, they had to work. I mean, we feel like they've got 5 passports, and it's so egregious that they are going to take off, we're never going to see them again. The other is public safety. And we're going to review both of these through this presentation, but the synopsis basically is we're holding people, way too many people, way too long, and it goes against the spirit of what this country was built on. So because my time is limited, I wanted to spend more time on the last 2 pieces, but I will give a quick history of bail here in America. You know, obviously, we didn't just come up with our system of laws in a vacuum. So Tim Schnacky, very good friend of mine, wrote a piece, and if you have smartphones, I should have said this before, if you have smartphones, we're going to have a lot of QR codes. So if I talk too fast or you have questions or you like to even reference where I pulled this information from, because this is not Aaron telling you what to do and how to think and coming up with this information on my own. I reference everything that I bring up today. So the QR codes are going to be available. I believe the slides will be available, or you can email me directly and I'll send you this presentation. And you can just use the QR codes and pull up the information and read it for yourselves. Tim Schnacky has done a lot of work in the pretrial field over the last 20 years. He wrote a informational booklet. This is available through the National Institute of Corrections to download, and the QR code goes right to it, so you can read it yourself. But basically, what he wanted to point to was how words matter, right? Previous presenter came up, and we're talking about using inappropriate language to describe something because it's either funny or that's how we have marginalized people, or words matter. And so when we talk about bail, what is bail? What is your definition of bail? If a money amount comes to your mind, that is not the right answer. Bail is not a money amount. Bail is a process of release. It should be, you are going to be released unless. But what it's turned into is a way to keep people in custody on arbitrary amounts of money or schedules, whatever you want to use. What's the purpose of bail? Again, if it's a process of release, then a bail hearing is to talk about what? How you're getting out. But instead, too often, it's about how we're keeping you in. Okay? The purpose of bail was always to maximize release. Conditions are where things come up and become reasonable. Again, these words have meaning. Reasonable assurance. Is that a guarantee? Absolutely not. There are no guarantees in life. And when you're dealing with humans who have emotional decisions, intelligent decisions, thought out decisions, whimsical decisions, it's not a guarantee. So I talked about there's only two reasons, right? Only two things we're considering. Will this person come back to court? And will they stay out of trouble? Will they not be a public safety risk? And they need to be the least restrictive necessary. So, Galveston County, if you're not familiar, got sued in 2016, 2017, Booth case, basically talking about financial questionnaire, financial affidavit. Do you have the ability to post the bond that I'm putting on you? Went through a long process. We now provide a financial affidavit questionnaire that is utilized by the magistrates to determine the best conditions for this individual. However, most of the time, what I hear is individual says they can afford $200. Okay, I'm going to set their bond at $2,000. Why? Well, because that's what they need to use a bondsman to get out of custody. Okay, so that $200 is just forfeit then, right? They say that at $200. $200 is probably a lot of money to this individual. So if I put $200 as the bond, and I know some people probably were like, what? $200 for a bond? If I put $200 for the bond and that's what they can afford, guess what? They come back to court, they get that money back. Huh, okay. All I gotta do is come back to court? Absolutely. Because you cannot revoke or pull bond amounts when they commit new crimes in the community. That is not what that money is set for. It is only returned to court. That's only failure to appear. I fail to appear, I lose that money. Okay. Keep that in mind. The bond is that obligation, not guarantee. Basically, they are saying, yep, I understand that I am forfeit this amount. If you or I are arrested, not saying that would happen, but if you're in Galveston for any of our celebratory weekends, there is a high probability that could happen. Biker rally is this weekend, so come on down. But if you were, there is not an amount of money that is going to keep you or I likely in custody. Because as practitioners, we know if we come up with that money, we can go home. We don't have to use a bondsman. We don't have to leverage whatever commodities we might have in order to secure our freedom just to walk out of the jail. But that's not the case for the people that we normally see on a day-to-day basis. I've worked in 3 different distinct jurisdictions as well as with other different federal agencies. I just referenced my ruby red state of Kansas, Wizard of Oz, Dorothy, yes, no place like home, good times. And I'm at Jayhawk, anybody, anyone, KU? It's all right, Rock Chalk, Jayhawk, all right. Bail in Kansas, what are these statutes? Talk about the Kansas Bill of Rights. Shall be bailable, releasable, not shall be $10,000, not shall be $5,000, not shall be on electronic monitoring. Bail, process of release. Kansas statute says purpose of this article is to assure all persons, regardless of financial status, shall not needlessly be detained. Excessive bail shall not be required. California, sapphire blue, or so people think. California, a person shall be released. Excessive bail may not be required. Take into consideration the protection of the public, seriousness of the offense, previous criminal record, and probability of appearing at court. Texas. All prisoners shall be bailable. Process of release, releasable. Shall not be excessive. Why is this language here? Kansas, Texas, California, all became states at different times, but all share similar language. Why? It's not rhetorical. Does anybody know? Lawsuits, absolutely, that has happened, yes. But this language was in the constitutions of these states. Why? The U.S. Constitution, right? That's the way our government works. We have federal law that dictates the minimum for the states. This is what you have to have. Anything you deviate from cannot be less than what we have set. It actually comes from the English Bill of Rights. 1689. Was our country founded at that point? Absolutely not. We were much like Australia. They sent their problems to America. Right? Gosh, that was such a good tee-up. I loved his presentation. So good. English Bill of Rights. We adopt this and we talk about excessive bail because in England at the time, if whoever was in charge didn't like you, they put you in what was called the Tower of London. And it's not a nice place. That's how they dealt with their political enemies and or people they didn't want to deal with. Excessive bail ought not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. However, where did that term come from? Why do we label excessive bail in our Constitution, but we do not define bail as a process? Doesn't make much sense when you think about it. So, since we don't define it, and it's not a federal right to be released, there's no federal right to bail, it's just the federal protection that if you are subject to bail, it cannot be excessive. But who determines what excessive is? Well, we haven't done a very good job because we've had these lawsuits. When you cannot define it for yourself and you cannot define what it should be, it's typically defined for you through lawsuits and through other settlements. So money as a criminal justice stakeholder, this is also by Tim Schnacky. He goes through and lists how money has created a lot more problems than it's solved. For our generation, we have never known this process not to involve money at some point. But before us, and before the turn of the century, 19th century, 1900s, money wasn't part of it. We only started using money as a surety instrument because we ran out of personal surety. New York becomes overpopulated. They can't figure out how to locate people anymore. All right, well, now we're going to put a money amount on things. Because we have done that, we have an entire century's worth of issues. And so money is now used as an instrument to also determine risk. It also delays and prohibits the release of people who should be released. And this goes without saying, anything that brings money into an equation is automatically going to have an us and them effect. Racial and ethnic disparities are going to exist in any system that is based on wealth. So we have Stack versus Boyle, 1951. Our first big federal legislation. What happens in Stack versus Boyle? Well, the Supreme Court found bail could not be set higher than what was reasonably likely to ensure their return to court. Reasonable likelihood. It set these individuals' bond at a $50,000 mark back in 1951. The history of this case, we had 12 co-defendants, all charged with conspiracy, because back in the days of McCarthyism, if you even somewhat were whispered to associate with communism, you were labeled a communist and an enemy of the state. So we have 12 people arrested, put on, giving them a $50,000 bond. 1951. It's $500,000 today. What the Supreme Court said was, you can't do that. You cannot just give a blanket amount. You cannot just line up 12 people and say, this is your amount. This is the cost of you being released. Every decision has to be individualized. Now, I've listened to multiple recordings of bail hearings across this state as well as across the nation. And I can tell you, they're individualized, but they're all the same. So, yes, it's just you standing there, but I can be Wheel of Fortune with people, and it's going to be the same script every single time. Upon reviewing the facts of the PC affidavit and have found probable cause to exist, considering the financial questionnaire that was presented and the criminal history of this case, I set your bond at enter amount here. It's funny, I've never heard anybody say, you're free to go. I've not heard that. Has to be individualized. Talking about those financial resources and their availability to actually fight. Where are people going? I love the FTA argument because, again, I work with law enforcement. And when I say, hey, individual Joe Blow didn't show up for court today, can you help me locate where they're at? They're not responding to my call, text, mail, whatever. Oh, yeah, I saw them down at 7-Eleven. Do you need us to go pick them up? So you're telling me that using our resources that we have available and our frequent flyers, we know where they are. So they're not really a flight. It's more likely they don't show up for court, correct? But they're not going anywhere. They're not leaving town. They're certainly not leaving the country. So again, when we talk about money, money was automatically seen as a bad idea. It took a little while because, of course, things don't happen in a petri dish, but back before there were cell phones, we didn't have the ability to communicate as worldwide and as quickly as we do now. And so it takes a while. People think using money is a great idea. It spreads across the country. But in 1961, they're like, okay, look, New York's jails are overcrowded. We need to figure out a way and who we can release safely back into the community. Manhattan Bail Project comes along. Demonstrated those with strong community ties, in lieu of financial conditions, continued to follow up and show up for court. So they could be safely released and come back to court. Because public safety at this time was not a consideration. Again, you have inherited a system that has had multiple revisions and gone through multiple changes over time. Founding of the Vera Institute, which continues to do this work through this day. So Bail and Criminal Justice Conference came in 1964. AG Robert Kennedy, Chief Justice Earl Warren come together. Emphasis upon financial aspect of bail is common to both the federal and state systems and is a weakness of both. That is the Chief Justice at that time. So then we have the Bail Reform Act, 1966. Non-capital cases have a statutory right to be released pending trial, subject to judicial review. Vista Bail Program comes along. Volunteers in Service to America in Baltimore does the same repeat process that Vera did in New York. Defendants affording bail could go home and support families. Those who could not waited in jail. So this is not a new issue. 97% of defendants released on own recognizance returned to court. Bail Reform Act, 1984. So we think we have fixed an issue with legislation. We find out that that is not the case, so we have to have yet a second round of bail reform. Introduce preventive detention based upon public safety. Subject to criteria. Violent crime, specific felony charges, possible life sentence, and repeat felony offender. There's a part to this that comes up. 1988, we have what's called the Salerno decision. For those of you who are not aware, if you want to really think about, is this person a danger? The test that was used was Mr. Salerno. He's a crime boss. Public safety was an issue because if he was released, he would effectually find who the witnesses were, and there would no longer be witnesses. Is that the standard that you use when you talk about public safety? When making release decisions? In our society, Judge Rehnquist has been quoted many times, but in this instance, in our society, liberty is the norm, and detention prior to trial without trial is the carefully limited exception. There is no other way that we can effectively manage this individual in the community, so we have to keep them in jail. At a cost of Texas, $70 a day. California, $120 a day. Kansas, $48 a day. Those numbers may vary depending on where you live and what resources you have. But shift in jail usage. So we saw public safety being able to be a carefully limited exception to hold people in custody, but unfortunately, what do we see? The jail populations explode because these people are so dangerous, we cannot do anything else with them. All your jail growth in the last 30 years has been driven by people who have not been convicted of anything. That is not what jail's for. That is not the purpose of jail. My sheriff in Kansas was not on board with our program until he had to pay for an individual having a heart attack in the booking area. He got stuck with a $50,000 bill that the county had to pay. And I said, he could have gone home. He's eligible. So then the sheriff got on board. Impacts of pretrial detention. Research. Research has shown. I am a practitioner. I know that I deal with attorneys, legislators, people who like to see the facts, right? Friday, Sergeant Friday, just the facts. Give me the facts. Okay? I'm going to give you the facts. People who are in custody are more likely to plead guilty. I can only wonder why. Are jails typically clean, nice places to be, safe places to be? No. So I'm going to do whatever I can to get out of jail. That's quite a leveraged position the district attorneys have. Defendants detained for the entire pretrial period, which is typically longer than they would have served had they just pled guilty, are more likely to be sentenced to jail and or prison for their case. And convictions happen 3 to 4 times more often than someone who was able to secure their release prior to sentencing. Those sentences were also 2 to 3 times longer. Now again, this is not me telling you. This is research, and the research is quoted, and you can read it. And this research has been replicated in different jurisdictions across the country over and over and over again. This one, when I first got involved in the pretrial process, this last point is where it kind of stuck with me. So you are destabilizing someone. Now, I am not saying everybody needs to be out of custody. Don't get me wrong. There are people who do need to be in custody. They are a public safety issue. But if they're probation eligible, even if they pled guilty, you are destabilizing them and then expecting them to become reestablished upon release and get all those things that they had before, except now they have a conviction on their record. And those of you who are practitioners who have to work with these individuals every day know that having a conviction on your record severely limits your ability to gain employment, to gain housing, and pay all those fees that they now owe, right? So you destabilize them. Our process destabilized them to begin with, and then you want to turn around and say, now you need to go do all that again. That's a problem within the system. Money bail does not equal public safety. And everybody's like, oh, I don't believe you say that. I don't know why you say that. Justin Michael Love, these are all Texas cases. I have a whole folder of cases from California, from Kansas, and I'm collecting those from Texas as well because I do live adjacent to Harris County, and the news programs down there have a program that's called Breaking Bail. And they don't understand the process. They just like to report on the people that get out and commit new crimes who are out on bond. Fair enough. Okay. They're not telling the whole story, but that's fine. Justin Michael Love posted $565,000 in bonds. He's accused in a 2015 murder, and bond was only revoked due to constant harassment charges through 2021. Corey Hodge, 2021, posted a total of $370,000 in bond. April 2021, July 2021, accused of killing 2 more individuals. Now these, again, the news likes to report that these are all PR bonds, but that is not true. I can tell you that. But it makes for sensational headlines. It gets people's emotions going, and that's how that works. Devin Jordan, 2021, posted $1 million. And he's already charged and on bond for 2 capital murder charges. What I advocate for is for judges to follow the current law, because current law already allows for individuals like this to be held without bond. There is no reason to set said bond for these cases because current law allows you to hold them. You don't need a legislative fix. While I appreciate the legislative process, and I understand why Senate Bill 6 was such an important goal for last legislative session, it doesn't fix the issue. Damon Allen would still be dead because the individual who got out posted a money bond, which is still happening across the state right now. You do not have a right to cash a surety bond. New Jersey enacted statewide reform a few years ago. In this case, Third Circuit stated this individual, Mr. Rosen, I believe, got in a fight at a bar. The judge said, hey, I'll let you out, but you're going to be on electronic monitoring. I don't want electronic monitoring. I've never had to do that before. I just want to pay my bond and be gone. Took it to the appeals court. Third Circuit said, an insurance company, which are what the bonding agents are, that will lose money because of the law change, does not have standing to even challenge the law. Understand that the surety process is not a criminal process. It is on the civil side. To get an insurance company to pay the amount that is owed to your county for this individual skipping bond, it takes an act of God. That's not common here to just Texas, that's nationwide, because the bail process is a multi-billion-dollar a year process that feeds off a public process. National standards, again, created in consultation with the American Bar Association, the National Pretrial Association. There are many different components of what an effective legal and evidence-based system can look like. And it considers the best practices. Reform Efforts in Practice 2017, National Institute of Corrections actually put together a framework. This is another publication. If you do not have a pretrial process in your jurisdiction or you want to create one, this is a step-by-step free guide in order to show you how to do so. And then the best quote I've ever been given is, you cannot improve what you do not measure. Anecdotally, we have all kinds of examples. Yeah, this happened, this happened, this happened. Well, okay, that's one case. What happens in your system? You cannot improve what you do not measure. National reform. Some of these names you will know. Some of them you like, some of them you dislike. How you feel about them is irrelevant to this conversation. Understand that at the national level, this has been looked at. Now, I don't pretend to think you'll get any of these people in the same room together at this point, but at one time, this was something that both parties thought were important. They've never been able to get it passed nationally, but many states have. Kentucky, Illinois, Oregon, and Wisconsin outlawed commercial bail. They do not use it. There are many other states that have followed suit. New Mexico changed their state constitution, 2016. New Jersey changed their entire process, 2017. And Illinois is set to enact what has been labeled as the Purge Act, because that's catchy, I guess, and they think that all these criminal people that are going to get released are going to go out and commit all these mass crimes. But hey, newsflash, all these people are getting out anyway, and they're coming back to your communities. Do you want them stable, or do you want them unstable? That's a question that only you can ask. Texas litigation, I talked about this a little bit earlier. O'Donnell versus Harris County changed bail practices for misdemeanor arrestees. We talked about Stack versus Boyle. When you look at a schedule, it is illegal based upon the Stack decision. But I'm pretty sure you can ask anyone in your jurisdiction and say, hey, do we have a bail schedule? Well, it's a schedule that the officers call the DA's office, and the DA office says, yeah, this is the recommended amount. Is that recommended amount individualized at all? Well, no. That seems like that's a problem. And it is. And Harris County got sued. Challenged bail practices for misdemeanor arrestees. Cannot use a schedule. It's not individualized. Violation of the Constitution. Dallas. Davies versus Dallas. Challenged bail practice for felony cases. And they're like, hey, you know what? If that works for misdemeanors, it's got to be the same for felonies. And it was. In our Booth case, challenged bail setting practices without an ability to pay determination. Now, and we provide attorneys at these hearings, which is fantastic. It still doesn't get rid of the queue. It still seems like it is a list that people check off, 15, 17 hearings. But at least the process has changed, and it is moving forward, and it is better overall, in my opinion. So think about all of these lawsuits, and think about how hard it is just for a normal person to try to navigate this process. And now throw in the IDD, and now throw in those without any kind of support. Because this does have an effect. And Texas, to its credit, has a law on the books with 1622. We're going to talk about that. So Senate Bill 6 came along, resurrected from the dead, as they say, passed special session in the 87th legislature, and related to procedures for setting the amount of bail, release of certain defendants on monetary and personal bond, and who was eligible and who was not. They actually created a standardized list of violence, what are considered violent charges, reporting the information pertaining to bonds, training and recertification requirements for magistrates from approved providers. Now, when I have reviewed this information with my local judges as well as statewide judges, who's a magistrate? All of you are magistrates. I'm not sure when this was put together that the thought was we are going to train the entire state's judiciary because we think that it's only going to affect a small number of people. So for those of you who know, we now have what's called the PSRS, which the Public Safety Reporting System, that went live April 1st. And this was to help standardize this process. Gives you a bail form, gives you a nice, now I'm not saying it's not nice, I do appreciate not having to look through 16 pages of criminal history and trying to figure out what's there, what's not. The summary page is fantastic. Criminal history summary page, I love it. Staff love it. They don't have to sit and go through 32 pages. It's good times. But the magistrate shall, and I love the law, and again, words have meaning. This is not a may, this is a shall. Magistrate shall consider the PSRS for defendants charged with a Class B or misdemeanor higher offense. So what does that look like? Remember when I said that the surety system was a multi-billion-dollar average amount of bond type? Personal bonds, when they're utilized, about $5,000. Surety bonds, they're always utilized, $20,000. I don't know how many 15, 17 hearings you have. But if the average amount going out of your already marginalized population is $2,000 at a time, just so they can secure their release from custody, that takes a lot of food off the table. That takes a lot of months of rent off the table. Bond decisions. Personal bond, statewide. 14% get personal bond. And you're like, wow, Texas must be a really hard state. We must have a lot of felonies that we deal with. No, absolutely not. 60% of everything that drives the jail population is misdemeanor A and B. What? You're telling me that we can't find a few of those people to put on PR? Now, Galveston County had to make a lot of changes, and I understand that. And not every jurisdiction has a 1742 personal bond office that can provide some type of compliance and supervision out in the community, as well as provide all these other services. I do understand that. But the Vera Institute in New York City didn't have that. Vista did not have that in Baltimore. 97% of the time, those people came back to court. Most common charges, DUI, first time. Possession, controlled substance, less than a gram. Assault causing bodily injury for the family. DV, hey, got me there. I'm not saying that you need to return those people back to the community, but possession of marijuana, criminal trespass, that is the meat and potatoes of what's driving the jail. And that's not me telling you that. That's the data that's been collected just since April. And I'm sure that, I know OCA is presenting tomorrow, and we'll go into more detail about the PSRS and Senate Bill 6, but it is what it is. That's the evidence, right? Those are the facts. Surety versus assessment. We talk about risk assessments. Everybody loves that term. That is the security blanket for the judge, because the assessment told me so. I didn't want to let this person go, but the assessment said this person was releasable, appropriately releasable. Because I'm not blind to the fact that the judges in Texas are elected. Most magistrates are appointed, but they like to keep those appointments. So they will do what is in their self-interest versus what is in the public's interest. And when I reviewed the oath that the judges have to take when they become judges, that is not in there, surprisingly. Utilizing money to release defendants does not appear to be related to whether people miss court or experience rearrest during the pretrial period. However, the assessment scores do associate missing court and experiencing rearrest. These results do not support the use of monetary release conditions and instead suggest using assessment instruments to inform decisions may result in more accurate and more appropriate decision making. So 1622 and 17032, why is this important? Texas, to its credit, put these pieces in place. Hey, we understand we do not want to use the jail as a warehouse for people who need services out in the community. Perfect, great. 1993. If you go back and make this correlation to the 17032 process, it is discretionary use of a PR bond for mental health clients. If they go through this process, they get identified, we don't want them in custody, we have other things for them to do, and they go out. The information I provided you as far as what we have from the PSRS, that 24%, the 20% that use personal recognizance bonds, that's only of the people who reported personal recognizance bonds. Half of the state has yet to report the use of any PR bonds. Think about that. Half of the state has never given a PR bond in the last 6 months. So how are they doing 17032 if they're not giving PR bonds at all? Are you telling me, because we've measured this, we know 30% on average, people qualify and fall under this statute, the 1622 statute. And then a smaller piece of that group moves over to the 17032 process. So you're telling me in Galveston County, we're not Harris, we're not Dallas, Galveston County, 30% of those folks come through, qualify, and fall into this process, that statewide, those numbers are going to be any less? Pretrial reform in Galveston County, we talked about this process. We had a process in place before our mental health court came online. Our commissioners court approved that. It went into effect in October. The process we did have was a straight connection from coming into the jail and having the financial questionnaire and assessment completed to our magistrate court. We identified those people who were possibly good candidates, and then we pushed them on to the DA's office and we had this hearing. The mental health court now takes care of this for us. We identify them and they are getting that information relatively quickly, and they move it forward and have those hearings there in the court. So I just wanted to leave you with this and why it's important. When will we stop letting tragedy dictate policy and law? How much better would things be if we just followed the laws that are already on the books? Thank you very much.